Today's topic is applying for disability. My name is Karin Dove, and I'm a volunteer for MassME CFS, and I help provide patient services on behalf of the organization, and I will be the moderator today. Our first speaker today is Kenneth Casanova, who leads the patient services team and has guided many patients through the disability application process. He is also the author of the organization's disability handbook, and we'll link to that later in the presentation. Our other featured speaker is attorney Ron Belluso, and he will add his perspective to Ken's presentation. Ron is a disability and workers' compensation attorney with Keches Law Group, and he is also a member of the MassME Board. He's going to describe the role of a lawyer in the disability application process and when you might want to get a lawyer involved in your case. Finally, we will also hear from Bob Robitaille today. Bob is a longtime ME/CFS advocate, and also he is the parent of an adult daughter with ME/CFS. And Bob will share his experiences helping his daughter win her benefits. And just before we get started, I just want to reiterate one thing. The presentations today do not constitute legal advice, nor do they cover all aspects of the Social Security disability process, nor are the presenters or the MassME CFS and FM Association responsible for any actions or responses to such actions that occur as a consequence of any material discussed in the presentations and the seminar today. So I think we're ready to begin our presentation. So Ken, take it away.
Hi, everybody. Good afternoon. Okay, fine. So this presentation will focus on obtaining Social Security disability benefits for individuals with ME/CFS and fibromyalgia who are sufficiently disabled that they can no longer continue working. Much of what we discuss will also apply to long COVID and to chronic Lyme disease. For more information on these latter illnesses, see our resource guide. First slide. Our association has published a handbook, How to Apply for Social Security Disability Benefits if you have ME/CFS, with additional information on fibromyalgia. For detailed information only summarized today, refer to the handbook and also to the website Sleepy Girl's Guide to Social Security. Links to all the websites and documents that I mentioned will be found in our resource guide. Next slide. Deciding to apply for Social Security disability. A person with ME/CFS, fibromyalgia, chronic Lyme, or long COVID, due to the chronicity and severity of their illness, may find they are no longer able to continue working despite their best efforts. Another person has been out of work for some time due to illness and is not recovering. Both persons, due to the loss of income, realize they must seek disability assistance. However, if you find that you can continue to work, but at fewer hours or in a less demanding job, you can ask for a job accommodation under federal or state laws. Next slide. Qualifying for Social Security. To qualify for Social Security disability, a person has to be permanently disabled and unable to do any substantial gainful activity. This means that a person must be unable to do part-time sedentary work on a predictable basis, and this condition has lasted or is expected to last at least 12 months. For instance, a person might be able to do 4 hours work at home or the office on 2 subsequent days, but then be unable to work for some days afterwards. Their ability to work is therefore unpredictable. Hence, this person would qualify for Social Security benefits. Next slide. Social Security regulations define substantial gainful activity as when a non-blind person is earning more than $13.50 per month in 2022. This regulation would appear to allow an applicant to earn this amount or less and still have their claim approved. However, over many years, we have found that it is better for an ME/CFS patient and a fibromyalgia patient not to be working during the application process, since Social Security may take any work as evidence that the person is not disabled. If a person has to earn some income below the $1,350, they will have to show it is unpredictable and requires only minimal work activity. Next slide. A quick note on employer long-term disability insurance. If a person has long-term disability benefits through their employer, they should apply before leaving their job. It's much harder to obtain those benefits if you've left your job. And most of these insurance policies also require that benefit recipients apply later for Social Security benefits. Next slide. Take a breath. There are two primary Social Security disability programs. The first is Social Security Disability Insurance, also known as SSDI, and Supplemental Security Income, or SSI. Each program has different financial eligibility standards. However, the standard of disability for both programs, both medically and functionally, is the same. Functional disability refers to the inability to perform work tasks and many of the activities of daily living. Again, that's functional disability. A person qualifies for SSDI by having paid Social Security payroll taxes for a set period of years and has also earned sufficient quarters just prior to their becoming disabled. There are no other income or asset requirements or eligibility standards. The amount of one's monthly payment depends on their income history. You can call or access Social Security online to get your statement listing how many quarters you have earned. Now for SSI, it's for those who don't have the work credits to qualify for SSDI. This program is for those with lower incomes, since one cannot have any substantial income above the monthly SSI payment, which is usually less than $1,000 per month. Most assets are limited for SSI to $2,000. After being approved for SSDI, there is a 2-year waiting period for Medicare from the date you were first disabled. During this waiting period or while applying, a person may be eligible for Medicaid. On SSI, you will receive Medicaid from the date of approval. Next slide. Applying for benefits. To apply for Social Security disability, call your Social Security office and state that you are disabled and need to apply. You should ask that an application be sent to you in the mail. Ask for a telephone interview. You should fill out your application prior to the interview so that your answers will be well considered and clear. Most applicants need to fill out the paperwork in steps. If you fill out the application online, make sure you can save your answers until you complete the application. Next slide. Take a breath. One date of importance is the date you became disabled. The date you became disabled. That is when you stop being able to continue working on a predictable basis. Some people have stopped working for a year or two before they apply. Give the earliest date that you became disabled from work. To backdate your disability, you will have to show through historical medical records that you have continued to be disabled since your date of disability. When you are interviewed for your application and when you fill out forms, be sure you communicate just how ill and disabled you actually are. If you've been having a few good days, you may be feeling hopeful and therefore tend to understate the severity of your illness. Social Security may then assume you are less disabled than you actually are. So be truthful, but just remember when you're filling out these applications when you have bad days or bad weeks. When you're filling out your own forms, answer questions in sufficient detail. However, if you write 20 or 30 pages, Social Security will wonder if you are disabled. The application process. The application process may be lengthy. The better and more comprehensive the medical and functional documentation submitted by your healthcare providers, the more quickly you may be approved. That's important. Next slide. There are 3 steps to the evaluation process. Next slide. One is the application stage, when you first submit your application and your providers submit your medical and functional documentation. Your application is reviewed by your state's disability determination service over a period of months. Now, these disability determination services are state agencies for each state. If your claim is initially rejected by them, don't despair or give up. Most claims that are eventually accepted are rejected on the first round. So if this happens to you, immediately appeal for reconsideration. Next slide. Reconsideration, and appeal well within the 60-day period so that you just don't wait too long and then things get lost and so forth. So you can submit further documentation of your disability, especially any doctor's letters that were not initially submitted. Again, rejections are also common at reconsideration. In fact, most acceptances occur at the next round. So immediately persist and appeal for, next slide, an administrative law judge hearing. You will need an attorney to represent you at this third stage. Normally, you may not need an attorney at the first two stages, but if you would like to consult with an attorney, our association can attempt to refer you. Do not expect an attorney to fill out your paperwork for you. That's a very rare circumstance. You must seek an attorney who has experience with Social Security disability and who also knows about your specific illness. This is important because an attorney who doesn't know about your illness is not going to really know how well your case is documented. Next slide. Okay, now we're getting to the documentation of your medical illness and your inability to work. This documentation is key to your success. So medical disability documentation. Your physician and physicians must provide medical documentation of your diagnosis as a medically determinable impairment. This is a requirement by Social Security that you have a medically determinable impairment diagnosis. For ME, CFS diagnosis, Social Security guidance relies substantially on the 1994 CDC CFS definition, which can also be supplemented by the better definitions, which are the 2003 Canadian ME CFS criteria and the 2011 ME International Consensus criteria. And those documents are in our resource guide. The one physician who primarily documents your disabling illness diagnosis must be an MD or a DO. A DO is a doctor of osteopathy. So Social Security requires that one of the primary physicians documenting your illness must be an MD or a DO. Next slide. For fibromyalgia, see the 1990 ACR criteria and or the 2010 ACR preliminary definition for how the FM diagnosis is made and documented in your medical records. So if you have other medical diagnoses, these should also be documented, and the doctor should explain how they contribute to your disability. If you think of a scale and you think of diagnoses being put into the one side of the scale, sort of the more weight it gives your claim. The doctor needs to also document the severity and chronicity of your symptoms and then evaluate the severity and chronicity of your overall illness. Severity is a word that is used by Social Security. So it's important for the doctor to document severity and also the chronicity. Next slide, which is number 22. Medical signs, symptoms, and tests. And for people watching with long COVID and chronic Lyme, the medical tests and symptoms and so forth are in our resource guide. So medical signs, symptoms, and tests. Social Security requires that the doctor document the medical signs and symptoms and also the laboratory and other tests used in making the medical diagnoses. Disability cannot generally be granted on symptoms alone. There have to be objective signs and also laboratory and other tests used in documenting the diagnosis. The major symptoms of ME/CFS can be found in the Social Security ME/CFS ruling. Also see the Social Security ruling on the evaluation of symptoms for disability claims. I will briefly summarize here. Symptoms and objective signs. So these are included: new onset of chronic fatigue not relieved by rest lasting at least 6 months. The 6-month guideline for diagnosing ME/CFS does not mean you have to wait 6 months before applying, as long as your doctor can document the diagnosis and state the illness will be disabling for at least 12 months. So severe fatigue following at least 24 hours after the level of activity. However, some people will go into PEM hours after too much activity. So this is really a flexible guideline, but the doctor should give instances of when you have PEM, a bit later. Other signs and symptoms: cognitive difficulties, muscle pain, sore throat, swollen tender lymph nodes, waking unrefreshed, headaches of a new type, non-exudative pharyngitis, frequent viral infection, sinusitis, extreme pallor, trouble walking. Next slide. If the doctor mentions anxiety or depression, he or she should clarify whether they are a result of having a chronic, serious physical illness. And what I mean there is, if a doctor mentions anxiety or depression, it should be clarified that this, in the case of ME/CFS or one of the other illnesses, that the depression is secondary and it wouldn't be there if you weren't physically sick for a long time. Let's see. At every appointment, ask your physician to document your symptoms and medical signs in his or her office notes. For fibromyalgia, make sure your doctor documents FM trigger points, also the widespread pain, ongoing fatigue, cognitive symptoms, and unrefreshed sleep. Next slide. Getting to laboratory and other medical testing. For ME/CFS, laboratory, blood, and other testing may indicate various abnormalities. See our handbook for a listing of various blood tests that a knowledgeable ME/CFS physician would perform. Next slide. Other tests and findings could include tilt table testing for dysautonomia, abnormal sleep studies, neuropsychological testing, exercise testing to show PEM or oxygen function, functional vocational testing, brain scans, and other tests. Now make sure that these tests are interpreted by an ME/CFS knowledgeable physician or a physician with one of the other who knows about the other illnesses. A physician or other provider ignorant of the illness may misinterpret the testing or not know what to look for. And this definitely includes neuropsychological testing. I just might comment there that a tester who doesn't know about ME/CFS, who does neuropsychological testing, might well interpret the data as showing depression. A physician may also document various treatments that have failed to provide any substantial improvement. Moving right along, next slide, 26, functional incapacity assessment. The next step after documenting your medical diagnosis and its severity and so forth, the next step is for the physician to describe in some detail how your illness is so disabling as to prevent you from carrying on significant work activity and many of the activities, the basic activities of your daily life. This would include documenting your inability to perform work tasks, sitting, standing, carrying weight, difficulty concentrating, problems with short-term memory, etc. Also, one or more of your providers should document your frequent inability to perform some of your necessary daily tasks, like doing shopping, making a meal, showering, cleaning, being out of bed, or having to sit much of the day. Next slide. Your doctor's reports. You must find a physician who is familiar with the illnesses, who understands your inability to work, and who will take the time to document your case to Social Security. You should ask your doctor if he or she is willing to document your disability claim. If your doctor is unwilling, you will need to find another doctor. Next slide. Your doctor should write a disability report or letter, providing in some detail how the diagnosis was made, how severe and chronic your diagnoses are, and how you are significantly unable to carry out work tasks and normal activities of daily living. It's not just enough, by the way, for your doctor to write like a 1 to 2 paragraph letter saying you're disabled and you have ME/CFS or long COVID and that you can't work. The doctor has to really spell out how he or she made the diagnosis, what your symptoms are, how severe they are, give details of the tests and signs, include his office notes, and then get into how the illness actually disables you functioning either at work or at home. Make sure for ME/CFS that your doctor fills out the Social Security form, providing medical evidence for individuals with myalgic encephalomyelitis, chronic fatigue syndrome. Next slide. If your doctor needs more information on the illness, she or he can refer to the US ME/CFS clinician's website. Also, our disability handbook provides sample disability letters reports that may help you or your family write a draft letter for your doctor describing your symptoms and your functional limitations that prevent you from working. Sometimes the doctor will find it helpful to have a draft, making his or her work less, and of course, some may not prefer that. The doctor, if willing, should explicitly state in his or her letter that you are totally disabled from doing any part-time work on any predictable basis, and the condition is expected to last at least 12 months. Next slide. Any of your other providers, including different specialists or non-medical providers, such as physical or occupational therapists, or even your counselor, should provide Social Security with confirming evidence of your diagnoses and functional limitations. Also, Social Security wants longitudinal evidence of your illness. That is your ongoing medical evaluations and treatments over time, including your inability to function. Normally, the emphasis is on the previous 12 months, but the more history your doctor can give about your increasing level of disability, the better. If you can obtain your medical records, including office notes and test results, you can make copies and submit them to Social Security yourself. That is in case your doctor or doctors are slow to submit your records. Do ask your providers to submit records in a timely fashion. Well, I hope you've been able to get some of this. I hope this has been helpful. Please be sure to see our resource guide for documents relating to Social Security disability, fibromyalgia, long-term COVID, and chronic Lyme. Also, if you go to our website, we have a whole section on disability, both Social Security and employer-related disability. You can download our handbook, which covers all of this in much greater detail. Thank you very much. I hope this has been helpful.
Thanks so much, Ken. And please see our links to the resources on our website. And as Ken mentioned, there's a lot of information there, so please feel free to look at that if you are interested. All right, welcome back. We are going to go to Bob Robitaille next. Bob is going to tell you a little bit about his experience helping his daughter with ME/CFS win her disability benefits. So now I'm going to turn it over to you, Bob. Go ahead.
Great. Thank you, Karen. Good afternoon, everyone, and thanks for providing us the opportunity to share our family's experience with you concerning the disability process. As a brief introduction, our daughter, Roby, who's 45, has had ME/CFS symptoms since in her mid-20s. Living in Texas, she managed to work until her late 30s when she could no longer do so. After doing a lot of research, she presented her ME findings to a local PCP there in Texas, who concluded with her ME diagnosis. Soon thereafter, she could not drive herself to work and lost the capacity to think. And as a student at Texas A&M with one class to go for a graduate degree, in psychology, and she had a 4.0 average. She had to drop out, unfortunately. So as a family, we decided that it would be best for her to move back to Massachusetts to be able to live with us, as she had exhausted her savings and was no longer able to support herself, and also to seek the medical attention in the Boston area for whatever they had to offer. After her visit with a local PCP here in Massachusetts, it was evident that she had no capacity to work. So she made out the initial application with the Social Security benefits, which I call phase 1. And Ken's already addressed that portion of it. But within a few weeks, we received notification that she did not meet the requirements for disability, even though she had described her lack of ability to sustain any kind of physical or mental presence in order to hold a job. At that point, we had 60 days to appeal the phase 1 decision. Over the next few weeks, she, and with a great deal of help from my wife and I, put together an 86-page reconsideration application package, which we thought was as solid as it could get. And we had letters, 4 letters actually. So one from her PCP stating the obvious, that she was not able to conduct any type of work, even sedentary, and that's a key word in the requirements. And by the way, the PCP letter was written by my daughter, and the PCP had no issue with signing off on it. So if the PCP is unwilling to write one, you could always ask, and I think Ken has already mentioned that, if they would sign a letter, make any changes that they thought was necessary. So the second letter that we had was from her employer in Texas, stating how her condition deteriorated over the last 2 years that she was employed with him, to the point that she could no longer function, not even on a part-time basis. The next letter was one that Kathy and I drew up, saying how her energetic life had changed to a dismal existence. The fourth letter was her own, saying how her life was with ME and what she was missing in life compared to what her life was before. And then the rest of the package was basically a bunch of tests she had over the years, ruling out other medical potential issues. So we thought we built a solid case that anyone in their right mind would agree that she was totally incapable of functioning even on a normal day at home, let alone any kind of full-time or even part-time work. Weeks after submission, the phase 2 attempt was denied, saying, amongst other false conclusions, that, quote, you can be on your feet most of the day, unquote, which, if anybody read the materials, could see that that was totally impossible. With that, we turn to the Massachusetts ME CFS organization for advice on the phase step 3, which is going to the judge for appealing the denial of the reconsideration. An attorney's name was provided to us by Ken Casanova, and we hired that legal expert who had handled many ME CFS cases with success. And that's kind of the key. I've talked to some other patients who have discussed things with attorneys, and those that don't have any knowledge of ME shouldn't be even considered. But anyway, after working the case for a few months, the attorney was able to convince the judge that our daughter was in fact disabled in accordance with the definitions. The good news is that she finally got her due with a positive judgment. The bad news is it took 18 months to do that. And she was fortunate enough to have, us to help her out and live with us. But there's many people that don't have that luxury, and it's unfortunate. So with the experience behind us, I've been helping Ken Casanova meet with patients asking for advice on the disability process. One patient recently asked if it was worth the effort to putting together the lengthy package that we submitted for phase 2 since it was denied. And the answer is a definite yes. Reasoning is simple. It's important to get the facts down while they are fresh. Also, although the chances are less than 50% probably, I think if the numbers are right, to achieve success in phase 2, there's still a possibility that can be successful. And I think Ken proved that he was successful in phase 2. And this bypasses obviously the lengthy process and expense of needing to hire an attorney and to go in front of a judge with no guarantees and now extending the period of time another few months to a year. So lastly, I'd like to leave you with this 5 bits of information, which I hopefully is here up on the slide. First of all, when describing your medical issues, please detail the reasons how those issues have impacted your life. It's really important to be clear about that. so that the people reading this material truly understand how this impacts your life. Secondly, closely monitor the processing of your applications. Keep track of what Social Security Administration is transmitting to your medical professionals. We didn't do that, and when we hired the attorney, my daughter gave Social Security permission to send the application to the attorney with all the background material that we had sent them. And we later found out that there was missing pieces from that information, which may have impacted the decision at the second phase. Third, suggest that you include in your application package a one-page historical summary of how your life has changed due to this horrible disease, which will provide a big picture for the person reading your package, making it easier for the reviewer to understand your situation in a nutshell. Fourth, make sure that the doctor, and I think Ken pointed this out, clearly notes in each visit the details of your situation and what he talked about, he or she talked about. In our daughter's case, that wasn't done by the doctor in Texas, and that cost her several months of when that ME diagnosis actually started, which impacted the retroactive date. So lastly, the only thing I could say is hang in there and think positive. If there's anything we can do to help, please contact us. And I guess that's it. Thank you for your time.
Thanks so much, Bob, for sharing your experience. That was helpful to see what you have gone through. And
Karen, could I just interject one thing very quickly?
yeah, go ahead, Ken.
Yeah, I left out something important in my presentation, which is that 80 to 90% of claims that are approved at the third stage at the administrative law judge level. So what I sometimes tell patients is don't just persist through the first two, through application and reconsideration, and get to that third stage level. If you do have a good documentation, you may be approved at the first or second level. But again, only about 10 to 15% of applications are approved at the first or second level. And the high majority of applications that are approved at the administrative law judge level. So if you get rejected at the first two levels, don't despair, get to that third stage and get a much fairer evaluation of your claim. And I know Ron will be talking more about this. Thanks.
Thanks for adding that, Ken. So it sounds like both you and Bob are really emphasizing the need for persistence in this application process. So thanks again, Bob, for sharing your experience. And for anyone in the audience, feel free to put your questions or comments in the chat if you have any questions for Bob and what his family went through. So we're now going to go to Ron Belluso. And again, Ron is a disability and workers' compensation attorney, and he's going to discuss the role of a lawyer in the disability application process and when you might want to involve one in your case. So Ron, please go ahead.
Thank you very much, and welcome to everyone here in the audience and the panelists. I certainly feel honored to be here. I think we have valuable resources here, and I would echo what the panelists have said. You know, it's a daunting task to think about disability. It's daunting to apply. And with my time today, I really just wanted to sort of go through that. You know, it's Social Security certainly doesn't make it easy. A little bit about my background. I've been with Keches Law Group for about 11 years, doing Social Security disability as well as workers' comp. But I've been doing Social Security for a total of 16 years. My first law firm, I was traveling the country, and I would do 2 to 3 hearings in all different states. So it was a national sort of experience that I got. And I mention that because what's made me very passionate about this is really how uneven you will see different judges handle really every case. And I think that that's what leads to a lot of frustration. There's, you know, judges are human beings. And when it comes to the final stage, which Ken was just talking about, the administrative hearing level, it really can be based on what judge you end up with, which is entirely unfair. And there's ways to assist with that. So that's really been my background. And, if we go to the first slide here, when do you need a disability attorney? Well, as you've heard from Bob Robitaille, sometimes you don't need one, and you can get on benefits through your own diligence. Now, as Bob said towards the end, when his daughter was facing a hearing, it was absolutely necessary at that point. And I would really agree with that. You're dealing with, at that third and final stage, you're dealing with judges and laws and rulings and highly technical things. A lawyer's job is to be persuasive, but do it in a fair way and convince a judge that this is a case I want to help out. And, there's a number of ways that us lawyers do that. Medical records, number one, and as Ken and Bob were emphasizing, I support that fully. A lot of times the judges I find are less concerned really with what conditions a person has. Believe it or not, they're more concerned with what are their doctors saying? Do their doctors believe in them? Do their doctors give strong opinions? And you're going to hear me use that word opinion a lot. Medical source statements. These are statements from your doctors about what they think your capabilities are. That could be with ME, it could be CFS, it could be FM, it could be long COVID, it could be a number of chronic conditions. And I would emphasize this too. Social Security, they look at every case really as a kitchen sink approach. In other words, don't forget, if you have other conditions such as diabetes, low back, difficulties, any kind of orthopedic issues that are overlaying ME, CFS, FM, chronic long COVID, use that to your advantage. Depression and anxiety is also something that can come as an overlaid factor. So I would just always emphasize, keep that in mind, that Social Security is going to be looking at all your conditions. So, do you need a lawyer? Well, that's a case-by-case analysis. Keep in mind too, it is not a given that an attorney will take your case. So it all comes back to the same thing. Whether you are trying to give the best application to Social Security, keep in mind that if you're seeking a lawyer at the last stage, that attorney is going to be looking for the same quality, because since we work on contingent fee basis, contingent fee means we're only paid a legal fee if we win the case. And there's many frustrating situations where we could spend years on a case and unfortunately come up empty-handed. It's horrible for all involved. First and foremost, the claimant applying for benefits, and then it trickles down to a lot of lost hours and hard work on the practitioner side. So that leads to my section here on fees. Fees are contingent. That means we have to win the case, and there has to be back payable benefits to an individual. Back pay means from the time you've applied to when the judge renders the decision, or at the earlier stages when if you're awarded benefits at the initial or reconsideration stage, that clock is running, okay? And that clock is running for benefits on a monthly basis. And an attorney is paid 25% of the back pay with a ceiling. The legal fees can never exceed $6,000. So the maximum fee would be $6,000, and that would require probably an individual taking, as in Bob's case as well with his daughter, 18 months or around that time frame in order to accrue enough benefits that 25% of the back pay equaled $6,000. The average fee in all of my cases comes out to be about $3,200, $3,300. And that shows you that oftentimes there's not as much back pay involved. So the legal fee could also be zero. If I help an individual, and I do help at all stages of the process, if an individual applies and is awarded at the initial, that's the first phase, Oftentimes there is no back pay. Unfortunately, and there's laws on this too, Social Security excludes 5 months of a person's back pay, just completely evaporates. And that's just federal law. And so what happens is if you are awarded in the first stage of this, you're likely not to receive any back pay. And that's something to keep in mind. So fees, it's really just a piece of the pie if you are awarded. But again, my point is, just like you're trying to prove your case to Social Security, if you approach an attorney, the stronger case, which really comes down to medical records and opinions, that word again from your own doctors, is going to be critical to getting a lawyer on board who wants and can really take that case on. What stage is a lawyer most useful? Really at the administrative hearing. And one of the reasons for that is, keep in mind, in Massachusetts, there's probably 12 or 13 judges total between Boston and Lawrence and Worcester, and they keep coming up over and over again. A good practitioner who's been doing this for a while will have seen and been in front of these judges hundreds of times and build up a rapport. Also, not only a rapport, but what is that judge looking for? What is that judge's preference on certain topics? And I think that, what stage is a lawyer most useful? At the hearing level. That lawyer's job is to be persuasive and be the expert, where a good judge will look to that lawyer and say, you know what, this individual knows this case inside and out, and I'm going to trust that I should award benefits. And that's really when, on a close case, it can having an attorney can really take it. That all being said, a person could go through the whole process without having a lawyer. And if we go to the next slide, I'll talk a little bit about what a hearing actually is. So currently, the hearings are all being conducted by telephone or video because of the COVID pandemic. And they've worked for the most part really well. I have not noticed any difference in the quality of what judges are asking or doing. There's been really no technical issues involved. And there's rumors anyway that Social Security is going to keep this as a permanent fixture, given that they've been able to speed up the time it takes to the hearing by probably 2 or 3 months. And in Massachusetts, we've gotten down on the backlog of hearings that have been waiting by again, probably 2 or 3 months. So the new technology certainly has helped. What is a hearing? A hearing, it lasts about an hour, sometimes an hour and 15 minutes. And a judge will look to the claimant. A claimant is a word for the person applying. The judge will look to that individual to add some life to this paper file that's filled with sometimes hundreds or thousands of pages of medical documents. And so the judge will also look towards the attorney for the legal arguments that should help prove this case. Ken Casanova talked about a lot of these arguments, rather a lot of these rules and laws that Social Security looks at. And there's not a ton, believe it or not, for ME, CFS, and FM. But again, I would emphasize not the specific laws involved. I'd emphasize if a person can have their doctor really behind them. And I do agree with Ken, an MD or a DO, but here's something to keep in mind. You could have great notes from a primary care doctor. It does not have to be a specialist. And again, as Ken mentioned, the longitudinal, that's a word for records over time. The longitudinal records can really support, if you have a primary who's seen you for 20 years, 15 years, this is a good person to ask to complete certain forms. And a lawyer can help give you forms that Social Security doesn't really give you. These forms are customized to the laws, really the third bullet point I have on this slide, the laws are what we call grid rules or rulings. So what are these things? Social Security puts together different rules for essentially every possible disability, impairment, condition that exists. And there's laws and rules really for everything. I will mention this, and it's something we haven't talked about on today's presentation. When a person is older, the closer they get to retirement age, the more likely you are to be awarded benefits. And the reason for that is just it's sort of baked into what I call these grid rules. Grids are automatic rules in certain situations where someone will be found disabled. And a bulk, as Ken mentioned, 80 or 90% of cases are awarded. I agree with that statistic. A bulk of that is when it overlays certain conditions with somebody getting to 50 years old, getting to 55, getting to 60 plus. Each bracket has different rules, and they, as you can guess, it gets a little bit easier to get on disability as you approach those different age brackets. And that's by design of Social Security. They feel that, well, we're going to ease up the rules and laws as someone would be getting closer to retirement age anyway. And so keep that in mind. If you fall into the category of 50 plus, if you have other conditions I mentioned a little bit earlier, those types of things can really help you. They can help you tremendously. Yes, each condition has to be severe, but things that you might not be thinking, foot issues, for example, or anything that it makes it difficult to sit, that can add, if you have ME/CFS, FM, any type of chronic chronicity, something as simple as back pain or herniated disc. These types of things can really move the needle as well. So we're using, as you can hear, I use all tools that are before me. And, you know, that's something important to keep in mind. I have on my second bullet point here, direct testimony and vocational experts. So the bulk of that hour-long hearing is going to be spent with the judge asking the claimant, the person applying, questions. We call that direct testimony. These are very formulaic. They're probably the same almost every case. And I call it the who, what, when, where, and why of disability. A judge wants to know who you are, why you're applying, what you've been through medically, what your background is in terms of jobs and work, and what your activities right now really are. We call those activities of daily living. And a judge sort of sizes up each case by listening to what these answers are. If you have a lawyer or if you're doing the process on your own, make sure that you're prepared for these questions. You can search them online and you'll get a pretty good, accurate list of what is probably asked. But again, it's going to fall into background, you know, high school education, marital status. It's going to go into medicals, the bulk of it. You know, what is going on with your conditions, treatment, frequency. And then finally, it's going to go into the third area, which is just day-to-day questions. Can you sit? Can you walk? Can you go grocery shopping? Can you drive a car? These are the common things that will come up with your direct testimony. When a lawyer is with you at hearing, we're allowed to ask questions after the judge asked. And what will happen is I will often keep a running list of what important questions have not come up. A judge does not like when I re-ask the same questions. They're very tight on time, as we can imagine. So I will only ask questions that are important and help move the needle in the direction of winning. Vocational experts, what is that? During each hearing, and they do this on every case, there is someone by telephone who's called a vocational expert. That's a fancy word for a job expert. This person will classify your past work. Aside from a person's conditions, their age, I would have to say the most important variable that I see is what their past work is. The more labor intensive your past work is, the more likely you are to win your case. And in other words, if I have someone over 50 with certain conditions, and their past work was, let's say, carpenter, for example. That is a high likelihood that individual will win under the different rules, those grid rules that we had mentioned. So you can imagine the inverse of this. Somebody has a job that is, say, administrative in nature, or requires high level of education, such as a teacher or somebody in a professional setting like an accountant. This is going to be a challenging set of rules to get around. Why? Well, Social Security is always trying to use that vocational expert, the job expert, to see if someone has what we call transferable skills. What that means is if you have a good education and skills at a desk, the likelihood that you have skills for, say, telephone work, or skills that are a little bit easier, but still light in nature, are there. And that can create challenges that us lawyers have to figure out ways to overcome during a hearing. So definitely those are factors. The job expert never asks you questions. And when I say you, I mean the person applying for benefits. It's something that the judge and the lawyer will go back and forth. And I'm allowed to ask the expert questions. And oftentimes I will get them to change their opinions. And what are their opinions? Well, during a hearing, a judge will ask things like, well, Mr. or Mrs. Expert, do you think there's transferable skills that John Smith has for other desk work, sedentary work? And I can ask cross-examination that can, and we've had a lot of good luck with showing that that expert is going a little too far. That's another reason that an attorney is, I would say, a very good idea during one of these hearings. The experts need to be challenged, and oftentimes they'll say things that are inaccurate. Time frame for a decision. Once your hearing is done in front of the judge, I would say with fairly good accuracy, 30 to 90 days, most administrative law judges will get a decision out to people. And that decision is in writing. It's very lengthy. It's filled with all kinds of legalese. It's not meant to read very easily. It has a lot of laws in it, and it's confusing. If it says fully favorable on it, that means you've won. And if it says unfavorable on the notice, it means that we have to do some more work. And that leads me to post-decision appeals, the last bullet point here. Yes, one of the most common questions I get as an attorney is, what happens if we lose that hearing? Are there other roads? And I always tell a person, yes. I say, we'll talk about that after the hearing, because let's stay positive. But just so everybody in the audience knows, yes, this could be appealed to what we call appeals council. That's a group of judges in Falls Church, Virginia, who look to see if the judge has made any errors of law. If that doesn't change the outcome, if we can't find any errors of law, sometimes that unfavorable decision will be affirmed. We could then appeal it to federal district court, which at that point, the likelihood of changing the outcome is not great. And I think the likelihood of finding a lawyer to do that, unless it's a really egregious case, is very, very low. And so, those are just some of the things that pop up. If we could go to the next slide. So just kind of summarizing this, increasing the odds of winning and prevailing here. So medicals. It really all comes down to what your doctors are saying. I find, again, judges are less concerned, as crazy as it sounds, with the exact diagnosis that you have. They're more concerned with whether your own doctors are behind you. And that has made the difference in so many cases that I've had. Supportive statements from physicians. And these can be paragraphs, these can be forms that are filled out that answer the critical questions. Could this person sit for 30 minutes? Are they going to be off task? If so, what percentage of a day, of a work day, would someone be unable to focus? Focus and concentration, remember, are huge. Can somebody lift? Social Security and really that job expert, there's 1,000,001 jobs out there, and some of them are extremely sedentary, which means sit down and very non-physical. So getting supportive statements from a doctor that say, a person could not focus, a person will miss 3-4 days per month. Did you know that if your doctor supports that you would miss more than really 2 days of work per month, 2 days per month, that under the law is enough to be found disabled if, and here's the big if it's well supported by the treating physician, as Ken said, an MD or a DO. And that is fact. That's the law. And we utilize that factor in almost every case that I have. Consistency of treatment, again, with ME/CFS and FM, our organization does have resources. If you're new to this diagnosis, if you're learning about it, that talks about what type of medical specialty could really help. And this could range from neuro to orthopedic to rheumatologist to your primary care to numerous other specialists. So if you have specialists involved, I think that that's a great thing. Consistency of treatment. I haven't met a judge that the biggest pet peeve a judge will have is, well, counselor, they'll say, I don't see any records for the past 3 months, 2 months even, they'll complain about. So, consistency of treatment is very big when you're applying for benefits like this, and it can completely increase the odds of winning. Next slide, please. One of the most common questions I get every week is, if I'm on benefits, can I then work? And going back to Ken's point from the very beginning, I agree with him. If you're applying for benefits, I would not suggest doing a part-time job at the same time. Again, Social Security, that's sort of a big no-no for them. It's an easy way for them to deny the case. So I would say stopping work, if you can and should, then you should. It will increase your conditions. So once you're on disability, though, what can you do? And this is important. I've had so many clients say to me, is that it? Can I go back to work? Am I written off? Do I, so I always say, Social Security would love nothing more than you to be off the benefit and back to work. So they've created a couple good programs, and I think that they're great. One of them is the work incentives program. Social Security allows a person to collect the monthly benefit check at the full level and try and dip their toes into working again. And this is called the work incentives program. Every 3-year period, a person can work and make any amount of money. There's no limit on it for 9 months during that 3-year window that Social Security looks at. So this can get confusing, and it can cause problems as well. So really, if you're on benefits, keep track of the months that you are working. They're not consecutive. I've had numerous people call me just this past month that they were, taken off benefits because they just went beyond the 9 months. It's not consecutive. They look at 3 years of that. The other really good tool you have, though, as Ken had mentioned in his introductory slide about substantial gainful activity. That's a fancy word for what does Social Security actually even consider work? And this is not based on hours. I've had so many clients ask that. It's based on the good old-fashioned dollar. And Social Security looks at $13.50 currently is the amount. If you are making less than that amount, and it has to be less, and we're talking gross numbers here. If you're making less than that, it's not considered work because the amount is not substantial enough for Social Security. So if you do get on benefits, and I tell clients as a rule of thumb, remember, certain months have 5 weeks in it. So be careful. $250 gross a week is a safe zone, I call it. That would add up to about $1,000 a month. And certain months that have 5 weeks, you're right at $1,250. So $250, maybe $300. You could work that amount and make that amount indefinitely while you're on benefits going forward into the future. So I know I could talk all day about this. I could probably talk for 24 hours straight about Social Security. So I wanted to sort of wrap this up and just give a quick overview. But thank you, everybody. And more questions will come up. And I'm here. I'm a board member as well for MassME CFS FM. So I'm not going anywhere, and I'm happy to help in any way, shape, or form that I can. But thank you very much.
Thank you so much, Ron. And I'd like to just extend my thanks to Ken and Bob, and again, Ron, for sharing your expertise today. I think it was really nice to get so many different perspectives. We heard from Ken about the rules. We heard from Bob about his personal experience, and then getting the legal perspective was really fascinating, and I learned a lot. So again, thank you. So, and by the way, you're getting a lot of comments in the chat. I just wanted to point that out too, that a lot of people are commenting. Thank you for sharing and discussing today. So we're gonna turn to the question and answer portion of this presentation. So if you haven't already, please feel free to submit your questions in the chat, and we'll go ahead. Let's see, we've gotten a lot of questions already, so I'm going to kick it off with this one. So this might be directed to you, Ron or Ken. Under what circumstances can children receive SSDI? So for example, if the parent is on disability or has died, may the child receive benefits as well?
Yeah, it's a complex sometimes question on that. And first off, so as Ken's slide had broken down, SSI and SSDI are the two programs. An easy way to think about the difference is SSDI requires work quarters to be paid in on the private sector. So a quick rule of thumb is if someone has worked 5 out of the last 10 years, they would be eligible for SSDI. So that answering the question, what circumstances for children? So a child does not have to work in order to get or apply for disability and end up with it. But just know that that's going to be an SSI case only. There's some exceptions, and I've been brushing up on this recently as well. There's a disabled adult child exception to this rule where if a person is found, you must show that they're disabled before age 22, but you could apply for SSDI for a child if their parent is retired and receiving regular social security retirement. And the other part of the question was survivor benefits, which is another sort of complex area we could talk about all day. In a simple way, if a person, their parent has died, if that individual was married to them, a surviving spouse, if they are over 50 years old and disabled themselves, they can get benefits from the disabled spouse. If the individual, the surviving widow or widower, is not disabled, they have to be 60 years old or over, but then they could also receive benefits through the survivor. And that comes in handy when the survivor doesn't have enough quarters or their social security rate would be quite low. Perhaps the deceased had more quarters and more pay in the system, and that could definitely help. So children, there's a whole other set of rules for being found disabled. We call that the 6 domains, but it's very similar in the sense that all the advice all of us have given today kind of applies to that, the same type of case. So there's a lot to it, but in a nutshell, yes, a child can apply. There's just a couple other things that you got to look at.
Thanks. Okay, let's see, next question. So Ken, this one might be for you. You know, a lot of doctor's appointments out there are pretty short, and so it's really hard for patients to cover everything they need. And then to add the conversation about disability and how patients are doing, do you have any strategies for how to go about that?
Well, obviously you need time with the doctor. And so probably, and Ron might have some ideas, you do need to ask the doctor at some point at an appointment before you're going to apply if the doctor will support your application and your case. And maybe the doctor could schedule, you know, some extra time for such an appointment. Often doctors will charge for doing a disability report. Also, there's some new rules. I don't know exactly who issued them. I do have the documents that under certain circumstances for people on Medicare, Medicare will pay for a doctor's extra time at an appointment if a person has some kind of chronic illness. And we can provide that information on our website or by email to people. Yeah, the problem, of course, is short appointments. But for Social Security disability, you have to get a little extra time to go through with the doctor what he or she needs to do. Ron, do you have any opinion on that?
Yes, I would agree with all that. I think judges, from what I'm seeing, are more open to, they understand that the practice of medicine has changed. You know, we're seeing a lot of nurse practitioners involved. Judges are giving those people weight to what they're helping write, as long as the underlying physician is really has all those same criteria of a lot of good treatment. So I tell clients, if you have that appointment, and you can find these forms through our resource or online, but they're called medical source statements, and bring them to the appointment, have them folded up in your purse or your pocket and say, Judge, this is for disability. And it's a lot of these are 1-pagers, which will ask those critical questions. How many days a month would you miss? Are you off task from focusing? And if your doctor has even 5 minutes at the end of the appointment, that could be the difference of your case. So I would say come armed and ready, and never tell a doctor, I'm getting this for a lawyer, or I'm getting this for this court case I have come up. Oh, the doctor will want nothing to do with that. Doctors don't really like lawyers. I mean, let's be honest, sometimes that can happen, and that's okay. But make it about yourself, which is the truth, which is, this is for me. This is for my daughter, my son, something. And I think that your odds of getting it back are much better.
Bob, do you have any quick comment from your experience?
Oh, Bob, you're muted.
No, I don't think so, Ken. I think you guys summed it up pretty well. I think with in Roby's case, back 5 years ago, we really didn't have many options. And when you think about the numbers of people in Massachusetts that potentially have ME, maybe 50,000, and you talk about the number of doctors that can talk the subject, it was kind of a difficult thing to do. So she ended up going to my PCP, and she was comfortable with her being a female. And, she said she would do everything she could to help. And she did to a certain extent by signing that letter for us. And she filled out that 6-page application, I guess. And she noted that all the conditions for my daughter were extreme. So she did what she could, but again, back then there were limited resources, and I think we still might have that issue today.
Great, thank you all. Okay, we have another question. How much documentation is too much, or what is the right level of documentation, especially for someone who has been ill, maybe a decade or more?
Give that to
think
Ron,
that-
I think.
Sorry.
Yeah, I would say you can never have enough. Sometimes you can overwhelm a judge in a good way with documentations. We've gotten to the hearing level sometimes where there's literally 3,000, 4,000, 5,000 pages of medicals, and I'd much rather have that than less. So I would say, it depends. If the documents are really ongoing office visits and things of that nature, great, bring them, all of them. So I don't think, I would say letters from family supporting, like sort of non-medical exhibits, I wouldn't go too many with that. That's really what the hearing at that last stage is for. But I would say if it's really your medical records, the more the merrier is the way that I say it. Yeah.
Yeah, I would just add to that. I mean, I've heard over the years that some patients are very precise and want to cover everything. So they might write out a 30 or 40 page answers to questions. And I've heard that some examiners and judges will say, gee, if this person can do this, maybe they could do a sedentary job. Do you have any comments on that? This is from the patient now, not from medical sources. I have heard also sometimes it's good for patients to keep diaries of their symptoms and their daily activities. Do you want to comment on that briefly, Ron?
Yeah, it can cut both directions. Remember, if it's a non-medical, and what we're talking about here for the audience is really, as you apply, if you're not familiar with it, there's certain sections for remarks and your own words answering certain things. So sometimes if there's too much there, it could open up certain cans of worms. In other words, judges will look to those answers and they'll really study them for things like vacations or walking a dog, or they're trying to find, or exercising at a gym, for example. They're looking for things they can talk about. So I would keep those to the point as a strategy, but definitely detailed in terms of always focus on your own limitations, I would say.
Great, thank you guys. Okay, another question we have is around consistency of treatment. And I think this especially applies to ME, where there are no FDA approved treatments. And so what do you do when you can't keep going to the doctor because they're not going to offer you a treatment? Do you just check in and let them know how your symptoms are every couple of months, or what should that look like?
Yeah, I'll answer that first and very quickly, and then hand it over to Ron. When you're applying for Social Security, and also afterwards, when reviews may come up every 2 years or something, they want to know, Social Security wants to know that you are seeing your doctor, so that they can document, so that you and your doctors can document your ongoing disability. And I always urge people, see your doctor every 3 to 6 months if you're on disability, maybe 6 months, so that you can check in with your doctor. Your doctor can document your ongoing symptoms and illness and inability to work. Because if a review comes up, especially, and you haven't been to the doctor, and Social Security asks you, how many times have you seen your doctor? Let's see your current records, your longitudinal records over the past couple of years, and you don't have anything, then you could be in trouble. Ron, do you want to take the rest of it?
Yeah, I would just say, to answer the question, really just never give up. If you feel you're with a doctor that can't offer much, and I'll have clients every week say to me, well, I can't go back to this doctor. They straight up told me there's nothing they can do for me. I would urge talking to our association, others in patient services, and finding another doctor, because that judge, and when you're in the context of applying for this stuff, they're really going to look to see that you just don't give up. And I think that would be my answer to that question.
Thank you, guys. Okay. How important is it that your client attends the court hearings, and is that going to affect the likelihood of them winning their case?
In terms of, I think the individual might be asking, is it better to show up to a hearing in person versus telephone or a video? I would say, if that's the question, that there's no real difference right now. You can't do a hearing without being on one of those three platforms, in other words. So the judge will not let a lawyer or a representative handle that entire process. You literally do have to be answering the questions, or the judge will continue the hearing until that person shows up. And if they didn't show up a second time, they would eventually actually dismiss the case. So it is a requirement to be there in some format, whether that's telephone, which works fine, or video, which is even better, or you can now ask through the pandemic for in person, but it's an absolute requirement that you're there.
And just one follow-up to that, just what happens if, you know, so many ME patients may be housebound or bedbound even, and so what if somebody is too ill to make it to their hearing? What happens then?
Yes, what I'll do in that scenario is I will document it. I will have the family member take photographic evidence of a person and how they spend, you know, if they're in a certain setup of their house, we'll take pictures of that. We'll submit that as a non-medical exhibit in conjunction with a letter that I would write asking this case to be awarded. I would say, Judge, this individual cannot even attend this hearing, and here's some evidence to show that. So that has come up, and we've fought very hard. If the judge doesn't really go for that, it would probably have to be a telephone hearing, but in some manner that judge would have to talk to that person at one point or another.
Yeah, if I could just interject, I mean, you say there's some video hearings. So,
Yep.
I mean, if a video camera could be gotten into the bedroom, the judge could see exactly what the problem is. Right. I don't know if that's if I'm just being quixotic about that or not, but
no, that's possible. Yep.
Okay, and another question we have is regarding the financial side of things, and I think this is related to SSI. How far in advance would one need to shed their assets to be under that $2,000 limit? And especially for, you know, maybe the person is a child who's going to be applying for this, or somebody who was disabled at that time.
So when you get the application in, you know, the difference between SSDI, the one with the work credits, and SSI, where you don't need quarters, is with SSI, you can't go back in time. When you apply it, that start date of benefits is from the date of application. So to answer the question, how soon would you have to shed the assets? It would have to be at the moment, really, you apply and going forward. They're never going to look into the past, because remember, Social Security can't pay past benefits. If you have work history, the nice thing is with SSDI, you can go back 1 year prior to the date that you've applied. So that is the big difference. So on the asset question, the local office examines each case to make sure whether someone has that level of assets. Now, they can look at things that are almost you wouldn't think are assets, such as getting free rent from a family member can factor it in, having a car. There's so many things that they look at. So that's a great question. And it's really just case by case analysis on that.
just to ask you a question, Ron. I understand with SSI, if you have a car, you can keep it if it's under a certain value. and you can keep your own home or abode. I'm not sure about that, but I believe I've read that. Also with, is it with SSI or just Medicaid? There's like a 5-year look back on assets. Is that just with Medicaid or does that include SSI?
No, that's Medicaid. Yeah, SSI, it's really from the application point forward, all those different, that level of, an easy rule of thumb is they're just looking to see really no assets. You know, if a person has a 401k or a person's receiving an old pension, if a person is married and their spouse works, but they don't, those are assets. And the spouse working, unfortunately, I have so many cases I want to help out on, and I just can't. The individual applying has not worked, say, in 10 years, and they're chronically ill. But if they have a spouse who's making money for the family household income, that individual is likely not going to be eligible. And that's a common problem that is very, very sad, because there's really no way around being eligible. If you don't have the work history, again, 5 out of the last 10 years of work, and say you're married and your spouse is working, but you haven't, SSI and SSDI are going to be out, unfortunately.
I'm just going to mention also in the future, we're going to have a volunteer coming on who is a paralegal who knows a lot about SSI and can help people with SSI. So if you have questions about SSI in the future, just contact the association. Also, I don't mean to belabor this question, but some patients getting on SSI have been able to set up some kind of trust where they can put their assets. But maybe that's, again, you can contact the association. We'll let you know about that.
Okay, Bob, a question for you. So if you were going through the process again, what are some things that you would be sure to do again that you did the first time? And are there any changes that you think you would make to what your process was?
Sure. So as I mentioned in the talk, I think, you know, from the get-go, we'd be a little more careful about what we were expecting our doctors, that we gave the list of doctors to Social Security and they communicated with them. We were going to be more on top of it than we were. I don't think we did enough due diligence. I think we sort of trusted the system and the system just didn't work for us. And I think, you know, just, you know, keeping the faith that somewhere down the line is a positive thing that's going to happen. And for us, it did take the 18 months, but I got to tell you, I've talked to other people with stories of 4 years and, you know, it took them that much time. So it's just, you know, keep going straight ahead and, you know, be careful, document everything. And, you know, I think as one of the two guys just mentioned, make sure that the doctor's on board. And for us, the PCP was very accommodating. She was very sympathetic towards my daughter's cause. She didn't know that much about the disease, but she was ready to, you know, to help support it. And I think that's another good cause as well.
Yeah, just on that, I would say, you know, some doctors' offices, their office manager or whatever, they don't get the records in on time. So I would suggest, and we do suggest this, that people get copies of their records, and even if they're duplicated at Social Security, send your copies in. Make sure that the examiners get the documentation on time, because they have a time frame for making a decision. And also just, you know, check with your doctor's office manager, with your doctor, and just say, you know, these records need to be in by such and such a time.
And I'll just add to that, what's great law in Massachusetts is if you're applying for Social Security, all records are free, okay? Never do you pay for these records, and that's state law. So keep that in mind. If you're advocating and applying for yourself, you should never be charged for your own medical records in this state.
All right, and I think we have a clarifying question. So if you are married or if your income is coming in from another source, does that affect SSDI or just SSI?
If you're married and you have income from another source.
Or just maybe if you're married and you have that income also.
So with SSDI, there's no limit on household income. So in other words, let's assume you've applied for benefits, you're on SSDI benefits, meaning you have a work history, you applied and then you were found disabled. There's no restrictions on how much money that you have in an account or how much a spouse or a family member is making for the household at all. There's just a limit on what you personally can make, which I outlined in that last slide, which was the substantial gainful activity level. So as long as you're not working, the household could have really an unlimited amount coming in. It's with SSI that the assets are critical, that they remain near zero almost, which is difficult, but that's what that law is for, unfortunately.
And the income also from a spouse or any other income coming in also applies to the claimant, I understand. So if your wife, say, is making, $2,000 a month, then you're probably not eligible for SSI. That's my understanding.
Yep, I agree with that. Yes.
And does self-employment affect this at all? Or what about cases where maybe you're getting a stipend for your work, but maybe let's say you're a grad student and you're getting a stipend for being a teaching assistant or attending the school? Are either of those two cases going to affect things?
Self-employment, that question comes up a lot. It depends. So with law, so many answers are, it depends. But with self-employment, it depends if you're paying Social Security taxes, payroll taxes. So a lot of times you don't have to do that. You could pay yourself differently. You could have an LLC, for example, that you're not paying per se, FICA taxes, but you're still completely above board with the IRS. You're not going to have the ability to really apply because you're not paying into the Social Security system. And you could possibly still apply for SSI, but again, you have to have really near zero assets. So if, let's assume you're a self-employed person who has paid in, of course, you're going to be eligible for accruing those quarters just like anybody else. And that's a great question.
Okay, I think we're getting to the end of our program here, so I'll ask one last question here, and it's about choosing an attorney. So would you have to choose an attorney from the state that you're applying from or where you worked? Are there rules about licenses and things like that that patients should be aware of?
Yeah, I think everyone should choose me. I'm the only lawyer that does this. No, I'm kidding. That's a great question. So there's really no rules on that. There's hundreds and hundreds of great lawyers in Massachusetts and throughout the whole country that practice this. There's also non-lawyer representatives that have taken lots of testing in order to facilitate cases. So just do your homework, I would say. Referrals are a great way if you've spoken to someone who's had a good result with somebody, but there's no rules really on it. I would urge people to avoid a out-of-state lawyer. I told you in the beginning, I was one of them for about 5 years. So I would travel the country doing this. The disadvantage that I've seen, and I'll be honest, is you lose home field advantage with the judge. So I'll be in, say, Texas, and the judges don't like that perhaps I'm taking business away from a local lawyer. And I think that hurts, to be completely honest. So I would say if you're Googling or something and you find an attorney, make sure you know where they're located. There's some great national firms, but just, I would say home field advantage is something that you probably want.
And I would just add, our association does have an attorney referral list based on feedback from people who've applied, who found that a lawyer was quite helpful to them. And I always say, make sure you get a lawyer who knows something about your illnesses, because that allows them to explain to the judges the details. Also, for very complicated cases, there are some national law firms that specialize in ME/CFS and some of the other illnesses we're talking about today. So those shouldn't be excluded, but generally the home field advantage thing is quite important. So if you're looking for a lawyer, don't just open up the phone book. You know, find out from somebody else who knows about the illness, who's had an attorney who was successful, or get in touch with the association and we can go to our referral list.
Great, thank you. And again, I just want to thank all three of you for being able to be here today and sharing so much information with us and being able to answer all of these questions. So I'm really grateful for all of you.
Can I ask you, are we keeping the questions so that if there are questions that weren't answered, we could answer them by email or something like that?
Mm-hmm. Yeah, we have a list here, so we can answer some of those that came in that we didn't have a chance to get to today.
And Ron and Bob, would you be willing to help with that if we do that?
Yeah, certainly.
Yeah.
Thank you. Thank you. So I just want to remind you again that the recording is going to be posted on the MassME CFS YouTube channel. So we will get that out as soon as we can, and we'll also post the slides on our website. So if there's something that you missed and you want to go back, that will be available to you. And I
also mention that we do at MassME CFS, we do disability counseling. We do help you find resources and so forth. So you can always get in touch with us through our website.
Mm-hmm. Yes, so you can go to the website and there'll be a contact us link there, and you can reach out if you have any questions or if you're interested in getting some additional information for your specific case, and we have some resources for that. I also just want to alert you that we will be having our next Sunday conversation next month on March 20th. So these sessions are on the third Sunday of the month at 4 p.m. Eastern. And next time we will be covering a functional medicine approach to complex chronic illness, which will be presented by Dr. Andrew Lenhart, who is a physician in Beverly, Massachusetts. Also, if you have any ideas for future programs or speakers, we welcome those always. And so you can email us at events@massmecfs.org and let us know what kind of topics you'd be interested in hearing about. And these conversations are really meant to provide practical information that patients can use in their daily lives. So again, if there's a topic you really want to hear about it, let us know. And finally, if you found this program worthwhile today, there are a few ways you can help out. You may make a donation to help support the series by donating online at massmecfs.org/donate. And on that same page, you can sign up for our newsletter. And if you donate $25 or more and check the Become a Member option, you'll also be able to hear about some of our members-only accounts, or members-only programs that occur periodically throughout the year. And the newsletter is just a great source of information to hear about goings-on or events in the ME/CFS community. So once again, I would really like to thank all of you for coming today, and we hope to see you again next month. So thank you. Bye-bye.